Do you have questions about your employment law rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9 p.m. on CP24.
Hi there and welcome. It is another edition of Ask a Lawyer right here on CP24. Good to have you along. Try to stick around for the next 30 minutes. I can guarantee you one thing, you will learn a lot. And that is the whole point of the show. John Scholes, I simply host it. All the heavy lifting is by your guy, Lior Samfiru, on your screen momentarily. EmploymentLawyer.ca to reach out to Lior anytime. And I always tell you to back it up with a phone call. Starts with that phone call. Make it happen. 1-855-821-5900. Ask at EmploymentLawyer.ca. That's the email address you can use. And we'll give you some more contact information throughout the show. No worries. So that's coming up. Main topic a little later on, termination without cause. A Q&A in that regard. So we'll get to that. Maybe some phone calls from our radio show, a bunch of other email questions, a lot of stuff to get through. So we will get to that in due time, in due course. But we always start off, Lior, with a case of day or a week that was, pal. What is going on with you this week?
Well, John, you're not going to be surprised when I tell you that I spent all week, like I do most weeks, talking about employment law, talking about workplace rights, and helping individuals facing those workplace issues. That's all I do. I'm here for 30 minutes. But when I'm not here, I speak to people, I email with people, I roll up my sleeves and get to work to make sure that those that have workplace problems have solutions. Whether you've lost your job, there is a solution. There's the rights. Whether you're being mistreated in the workplace, there are rights and there are solutions. If your job has changed, your hours, your compensation, your work location, all those things, they're rights, solutions, things that you can do. And as John says, it starts by reaching out. We'll give you that contact information throughout the show so we can have that private discussion. If you're not making that call, that means you're not enforcing the rights. Rights are really of no value unless you stand up for them. You enforce them, and at least you know what they are. By watching this show every week, you'll know what your workplace rights are. And I always like to start off with the situation that came across my desk. So in this particular situation, I spoke with an individual that started working for a company 10 years ago. Now, for the first 6 years, he was considered an independent contractor. He was working regular hours, but he was considered an independent contractor. He used to invoice the company, and they used to pay the invoice. So that's what happened for the first 6 years. Well, 4 years ago, company says, well, we want to shift you now to being an employee. We're going to put you on payroll. You're going to be a regular employee. He was happy, so that's what happened 4 years ago. Fast forward to now. Unfortunately, the company's going through a restructuring. They have to make a change and let this person go. And they say to him, well, you've been an employee for 4 years. We're going to pay you severance, of course, for those 4 years, and that's that. Well, he didn't think that sounded right, so he called me. He wanted to understand, really, does he get credit for the full 10 years he was there, even though the first years he was an independent contractor? Well, I was so happy that he called me because of the fact that, guess what? He was an employee all along. He was simply misclassified for the first 6 years. You don't magically become an employee just because the company wants you to go on payroll. It doesn't work that way. He was an employee all along. Remember, does not matter what the company thinks you are, what the company calls you. Frankly, it doesn't even matter what you think you are. If you look like an employee and act like an employee, you are an employee. He was misclassified. And the reason why that's important is now he has 10 years of service, not just 4. So he has to get paid severance for those 10 years. He's probably owed 12, 13 months of severance, not maybe 4 or 5, which is what the company thought they should pay him. I'm going to help him get that severance, but chances are you at home, you've been misclassified. If you think you're an independent contractor, it happens all the time. Don't assume that you don't have rights. You have rights, especially if you lost your job.
And a quick reminder, there is a section on that on the website, pocketemploymentlawyer.ca, by the way, that deals with independent contractors. If you want to break it down, you can use that on your own time. Again, pocketemploymentlawyer.ca. Radio shows, Leo and I do a ton locally here in the GTA. News Talk 1010. We're on there Sundays at 1 p.m. Get a lot of phone calls. We play them back here. We talk about them. And again, it's all for education and insight. Let's get to that phone call right now. Listen up.
Calling on behalf of my sister, actually. She's an employee for 31 years. Her paperwork said that her company had entered into an agreement to acquire the assets of the company. A letter sent home saying that, unfortunately, there would be some layoffs. She was given a form letter, "Dear employee, your services are no longer required," but they offered her no severance after 30 years.
Wow. What do you think about that?
Well, this is the type of situation where we have to do some more investigation. I want to understand what's actually happening there. Is this a bankruptcy situation where the company is bankrupt and someone is buying just the assets of the company? Or is it that some sort of a different transaction? If you lose your job in a bankruptcy situation, you may not get anything. But if it's some other transaction, some sort of a sale of a business or a restructuring, yes, of course you get severance. There's no way to let you go without severance. So the first thing is to determine what is actually happening here. What is this transaction? Once we know, the next question becomes, well, how much severance should this person be getting? What is the right amount? Well, for that, we're going to go to the severance calculator. You can find that at EmploymentLawyer.ca. So let's plug it in right now and let's see what that gives us. We know that this person is 57 years of age, in a sales role, been there for 31 years. No severance. We don't know why, because if you look at the bottom there, she should be getting as much as 24 months of severance, 2 years of pay. So remember, bankruptcy, probably very bad news. Anything other than bankruptcy, if you lost your job, big company, small company, sale of a business, restructuring, does not matter. You have to get your full severance. If you don't, you call me and I'll make sure that you do.
All right, we're off to a wonderful start, but we got to slide into a quick break. On the other side, our main topic, termination without cause. A quick Q&A. That is on the way as we continue more Ask a Lawyer here on CP24. Stay with us.
Do you have questions about your employment law rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9 p.m. on CP24.
Alrighty, welcome back. Ask a Lawyer right here. CP24, John Scholes, and as always, Lior Samfiru, EmploymentLawyer.ca to reach out, and the phone call and the email. Here's how that goes: 1-855-821-5900. Right below that, there's the email, ask@EmploymentLawyer.ca, and scan that QR code on your phone when you got a moment. You can do that as well. Okay, as I mentioned, we always have a main topic every show. It's kind of the foundation of the show. It's for education, it's for insight. Lior, termination without cause, Q&A. Number one, here we go. What does it mean to be terminated without cause by your employer, and how does it differ from a termination for cause? What do you think, pal?
So a termination without cause is the most common type of termination. Termination without cause means you're not being let go because of something awful that you did. It's pretty much any other reason. It could be a restructuring. It could be a cost cutting. It can even be a performance issue. But it's a situation where you're let go for the company's own reasons. It is legal to be terminated without cause. It's very common. Of course, it comes down to severance. What could make it illegal is if you're not getting your full severance. The opposite of that is a termination for cause. That can only happen if an employee is guilty of very significant misconduct, if that misconduct is repeated, and if the company has tried to fix that misconduct. Then maybe the company can terminate for cause and not have to pay severance. So the bottom line is this issue of severance is what distinguishes a without cause termination and a for cause termination. Most people, when you're let go, you're terminated without cause, and that means, as I said, your full severance up to 2 years of pay must be paid.
All right, Lior, second question. Do you have to sign back a termination papers or severance offer by the deadline? Because everyone has a deadline. This is where the pressure starts, right?
So most termination without cause, severance is owed, you get a severance offer, severance package. And guess what? That severance package almost always has a deadline. We need you to sign by Friday or whatever that date is. Remember, that deadline is meaningless. Your legal rights do not expire Friday at 5 or whatever that deadline. Nothing happens on that deadline. You have 2 years, up to 2 years to pursue your entitlements. It's a pressure tactic. That's it. Your employer may hope that if they give you that deadline, you're going to feel compelled to accept that offer. And why is that bad? Because chances are, really good chance, that whatever you've been offered by that deadline is not what you're owed. It's a lot less. And if you sign it, you can't get out of it. So do the right thing. Don't worry about that deadline. If you lost your job, call me so we can do this right.
We are working our way through the termination without cause Q&A. Number 3, Lior, this is the big question everybody wants to know. How much severance pay do you get when you're let go without cause? It's all about the cash.
Well, some people will say, well, I know, it's a week per year. Or some other people will say, no, it's 2 weeks per year. Guess what? Wrong. There are several factors that go into deciding how much you're owed. The main factors are your age, your position, and the length of your employment. The longer you work, older you are, and the more senior a position, the more severance is owed. And that amount can be as much as 2 years' pay. It can even be more in some situations. Remember, short service employees are treated disproportionately better. You may be owed several months of severance, even if you only worked for a few months. So it's not a week per year, it's not 2 weeks per year. Forget about that. You can call me to find out your specific entitlements, or as John said earlier, just go to the severance calculator. You can find that at EmploymentLawyer.ca.
All right, 5th and final question, Lior. Can the government, or should I say, should you let the government help you with severance and termination without cause case?
John, the government, the Ministry of Labor, the Labor Board, doesn't matter, cannot help you if you lost your job, cannot help you enforce or even understand your full termination entitlements. They can only advise you with respect to your minimum entitlements, a small fraction of what you're owed. So don't do that. For that, to understand what you're owed, you cannot contact the government. You need to speak to me. If you don't like me, that's absolutely okay. Call another employment lawyer. You can do that as well. But do not go to the government for that. You need to do the right thing so that you don't accept an offer based on bad information.
All right, let's move on. As I mentioned earlier in the first segment, you can catch Lior and I doing the radio show, specifically here in the GTA, News Talk 1010, Sundays, 1 p.m. So catch it this coming weekend. Get a lot of phone calls on it. We play them back, and we talk about them. We learn from them. That's the whole point. Phone call number 2 is upon us. Lior, listen up.
I got termination of employment letter, termination without cause. They're giving me notice instead of paying me out. Now, on the termination letter, it says they will pay vacation pay, but the amount is not stated. If I sign that I accept these terms, it says I can't go after them if there's a dispute.
How long had you worked for this company?
15 years. I'm in the IT field.
How old are you?
52.
Got some good information there, Lior. What do you think?
So every time you're let go, you're going to be asked, in exchange for accepting severance, to sign off on that severance package and to accept a release, to sign off on a release. That release document is very important because what that means is once you sign it, there's no going back. Once you sign it, you can't change your mind. That's what the company is buying. So you can't sign that until you know what you're getting. Now, he's concerned about vacation pay. I can tell you, even without knowing all the facts, that the vacation pay is probably the least of his concerns. He could easily be owed many months of severance. 15 years, he could be owed 16, 18, 20 months of severance, and 90% chance that he's offered less than that. So do not sign that release. Do not do anything until you speak to me. Too many people call me after they sign that release, and I have to break the bad news to them that they're stuck. They accepted less than what they're owed, and now I can't help them. Please don't ever do that.
2 phone calls were great. We'd like to squeeze in a third, but I got to wait till the other side of the break and get to more of that. Questions and emails as we continue. Ask a Lawyer on CP24. Don't go anywhere. We're coming right back.
Do you have questions about your employment law rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9 p.m. on CP24.
Okay, welcome back. Ask a Lawyer on CP24. John Scholes, and as always, Lior Samfiru from EmploymentLawyer.ca. Reach out at your leisure anytime. Before you sign or do anything, always make that phone call. At least get the information right. There it is, 1-855-821-5900. Ask at EmploymentLawyer.ca. And again, the phone calls, easiest way. You can always call Lior. We get those phone calls too. We play them back on this show, but a good way is to get on the radio show and talk to us live during the weekend. It is Sundays, 1 p.m. News Talk 1010 for a complete hour. We love having you on that show as well. Phone call number 3, Lior. Listen up. Here it comes.
I was dismissed from my job in regards to an addiction that I have. Got my final notice, my third notice in regards to any more time lost. that I would be dismissed. I confronted the company the following day and said, yes, I do have an alcohol issue. And my doctor was aware of my alcoholism as well. I was just wondering what rights I have. They did give me a severance with my vacation, but apparently the check's still in the mail.
What kind of job? What do you do there?
Truck mechanic, 10 years.
Approximately how old are you?
48.
Those are dicey waters for an employer to be treading on, right?
Well, let me tell you why. Because an addiction, in this case alcohol addiction, is considered a disability. So just like you can't be let go for other disabilities, maybe you have a herniated disc or something else that's serious, you cannot be let go because you have alcohol addiction. That's a human rights violation. That is something that is forbidden. So right off the bat, I have very major concerns about the fact that this person was let go at all to begin with. That should not have happened, especially when his employer knew about it. He can take whatever time he needs to take off to get better, to heal, just like with any other disability. So you should be upfront with your employer if you have a disability, in this case alcohol addiction, because once you tell them, they are forbidden for punishing you. So we know there's a human rights violation. The second question, of course, is that of severance. How much severance is he actually owed beyond just any human rights damages? So for that, we're going to go back to the severance calculator. We're going to go to EmploymentLawyer.ca and let's see what that gives us. So we know he's in his late 40s. He's been there for about 10 years. And we see right there at the bottom that he's owed up to 12 months of severance, up to 12 months, a year's pay. That's how easy it is, by the way, to use the severance calculator. You can find that at EmploymentLawyer.ca. It's free and anonymous. And keep in mind, that's in addition to any other human rights damages he's going to be owed.
Great call there, and I want to get to an email, Lior. We got time for that one. Here it is. I was injured in a car accident 2 years ago and had to claim long-term disability. Now, the insurance company says I can work, but my doctors disagree. If they cut me off LTD and I can't return to work, my boss will fire me. This is just a big bowl of wrongs. Says, what should I do? What do you think?
So let's deal with the employment piece first. So first of all, his employer cannot, should not, must not let him go as long as his doctor, as long as the employee's doctor says he cannot work. Doesn't matter what the insurance company says. If you have a doctor's note saying you cannot work, your employer cannot let you go because of that medical condition. They don't get to disagree. They don't get to say, I don't believe your doctor. They don't get to say, we believe someone else. They have to do what your doctor says. And if they let you go, that could be a human rights violation, a wrongful dismissal, you name it. Get that doctor's note, and that protects you. Now, the other issue, of course, is with respect to the insurance company. Unfortunately, it is common for an insurance company to cut someone off their disability coverage before they should, while the person is still following their doctor's orders and not working. Well, the good news is once they hear from us, they backtrack, they compensate, we deal with it. And to tell you how often this happens, we have a whole team at the office dealing exclusively with these disability issues. So if your insurance company won't pay you when they should, if they don't believe you or your doctor that you cannot work, let us deal with it. Let us make sure they either reinstate your own benefits, they don't cut you off, or we get you compensation. Don't take your insurance word for it. Don't do what they say. Don't follow their process. Let us deal with it and get it resolved.
All right, Lior, good stuff. We got time for one more email question. We'll do that on the other side of this break. We're going to get into right now and return with more Ask a Lawyer. Stay with us.
Do you have questions about your employment law rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9 p.m. on CP24.
Okay, and we're back. Got a couple minutes to go here. Ask a Lawyer, and welcome back to the show. John Scholes, Lior Samfiru. Lior, always reachable. Phone number is good, 1-855-821-5900, or email him as well, ask@employmentlawyer.ca. Scan the QR code and reach out anytime you would like. And that's how we're going to close off the show tonight. Lior is with an email. It says, can my employer put me on another temporary layoff? I was already on one a few months ago.
So we need to break this down a bit. So let's start off with this idea that for most people, that temporary layoff is not legal. Your employer does not have the right to automatically put you on a temporary layoff. That means that if your employer does do that, you can consider that layoff, or may be able to consider it, a constructive dismissal. You can treat that as a termination and force the company to pay you severance. That's a right that you have. Well, it gets more interesting or more complicated is if you accept the layoff. You don't have to accept it, but you accepted it. Because what happens, if you accept that layoff and you go back to work at the end of it, you're potentially giving the company the right to do it again and again. So you've opened that door that first time. So my concern here is that by accepting that layoff that first time, a few months ago, now the company has a right to do it, and now he can't do anything about it. I would want to know more. I would want to know, with that first layoff, was there a unique set of circumstances? Was there a good reason why he accepted it? Maybe we can still get him out of it. But I want you to be very careful with these temporary layoffs. You don't want to be in a situation where you go back to work for a few months, and then you work, and then you're laid off again temporarily, back and forth and back and forth. That's no way to work. That's no way to earn an income. So be smart and don't let that happen.
Is that temporary layoff, Lior, something that an employer can put into an employment agreement and the employee can try to get it knocked out of the employment agreement? A little back and forth, yeah?
So a company that wants to gain the right to put you on a temporary layoff, a smart company will put that in the employment agreement, will give themselves that right. You want to be careful. You don't want to accept something like that. Yes, you can negotiate that out of the employment agreement. Best advice I'm going to be able to give you about that is, if you're asked to sign a new employment agreement, let me see it, let me read it, let me tell you what it does and what it means, and then we can talk about how we go about negotiating it. There's other problematic terms in an employment agreement. For example, something that may limit your future severance, something that may give the company the right to change your job, your pay, your work location. You want to be mindful of all these things, not just your salary or vacation. Those are important, but there's other things equally important. So anytime your employer wants you to sign something, you know what to do. Have me see it, have me read it. I'll tell you what it does, and we'll talk about how to best negotiate.
All right, that is about all we got time for tonight. Again, just take a step back before you sign anything. Let Lior see it. Send it to him through email. Call him if you want. I'll give you that contact information before we get out of here one more time. The phone number, 1-855-821-5900. Ask at EmploymentLawyer.ca. Now, that website we've referred to and used actually a couple times on the show, as we do every week, PocketEmploymentLawyer.ca. You want to go there and catch us on the weekly radio show here in Toronto, GTA. It's News Talk 1010 Sundays at 1 p.m. And for all other information, as you probably know, cp24.com/askalawyer. And we'll catch you next week. Thanks for tuning in.